Good evening, everybody. Thanks for joining us. This is the call to order for the Aspen City Council regular meeting for September 24th, 2024. Could we have a roll call for attendance, please?
Councillor Doyle.
Here.
Councillor Guth.
Here.
Councillor Howenstein.
Here.
Councillor Rose.
Here.
Mayor Tory.
Here as well. This evening, we are starting off with a proclamation and a public appearance. So if you'll indulge me, I'd like to read a proclamation. Whereas the City of Aspen is proud to recognize Judge Brooke Peterson's significant impact on the community. The Honorable Judge has served on the Aspen Municipal Court for a remarkable 43 years. He's retiring on October 1st, 2024, a testament to his dedication and commitment to the community. Whereas Judge Peterson's commitment to serving the community is evident in his dedication in pro bono work, and whereas Judge Peterson is widely respected for his integrity, fairness, and wisdom, having earned the trust and admiration of the community through his impartial and ethical conduct, and whereas Judge Peterson's approach to municipal court has been characterized by careful listening, a deep understanding of the law, fostering a respectful and equitable courtroom environment, and whereas we may never again see such judicial styles such as shearling coats, cowboy hats, and Rolling Stone ties, and whereas Judge Peterson's strengths include his ability to explain complex legal concepts clearly and educate courtroom participants, have made him a valuable asset to the Aspen community, and he will be remembered as a fair and compassionate judge who treated all individuals with dignity and respect. And whereas Judge Peterson's legacy leaves a lasting impact on the legal system and the lives of those who appeared before him. Now, therefore, be it proclaimed that the mayor, the city council, and the citizens of Aspen do hereby declare that September 24th, 2024 be declared Judge Brooke Peterson Day in recognition of his 43 years of dedicated service to the city of Aspen, Colorado. As I was saying earlier to Brooke, I think he has sworn me into office 5 times. And today, as I was thinking about this, this is kind of paying him back. I'm now swearing him out of office. Thank you for everything. You're welcome.
Thanks, Brooke.
Thank you, Brooke.
Thank you all.
It's with a heavy heart and quite emotional for me to leave the bench after all these years. There are far, far too many people to thank for the time that I've spent, first of all, to the citizens of Aspen and who gave me the privilege of being here. I want to first of all thank my wife, Carol, and my family, my friends who have supported me for many, many years as the judge. I missed a lot of powder days on Wednesday because of court, but I think that overall it was an unbelievably valuable experience. I'd like to thank all of the city staff and all of the city elected officials, including all of you gentlemen who have seen fit to appoint me, the city staff who has supported me. I want to say special thanks to the Aspen Police Department who have been in front of me more often than they probably wanted to be, and thank them for always doing the right thing and always trying to take care of the community. A very special thanks goes out to the clerks who have assisted me, and amazingly enough, I've only had 3 clerks in 43 years. Jeannie Ritter, Reed Patterson, and Tracy Terry, who's my clerk now, and without whom the court would not function. I want to thank them from the bottom of my heart for everything that they've done, and their staffs. To my deputy municipal judges, especially Ted Garden-Schwartz, who's going to become the presiding judge. Ted, thank you for all the time that you put in to help me when I couldn't conduct court and when I could conduct court. And to Don Nottingham, who has recently been appointed as a deputy municipal judge. To the city attorney's office, it's been a pleasure and a privilege to work with all of you, and especially with my close and dear friend, Mr. True. And I wish all of you the best of luck. To those of you in private practice who have assisted me and argued your cases quite well in front of me, thank you. We've had a tremendous number of lawyers over the years that I've been the judge, and I've been privileged to learn from all of them. But especially to the citizens of Aspen, we have an unbelievable place that we live, and from the bottom of my heart, thank you all.
That'll bring us to citizens' comments and petitions this evening. If there's any members of the public that would like to share, absolutely, Rachel.
Well, good evening to all of you. I'm Rachel Richards. I live at Hunter Creek Condominiums, and I've lived here since 1978. A little time in between there. You know, I've taken a look at your information packet with the CDOT response letter, which very much mirrors their March letter and July letter, and now the September letter, all with the same answer, that as far as I can tell you, and as I've told you before, an EIS is going to be required to clear any sort of other alternative. And I think it's really time that we get that moving forward. This Monday, I had to come up from El Jebel with my husband. He had some medical work done very early in the morning. And so we reached the airport at about 8:58. And the backup started there, and we got to Main Street 39 minutes later at 9:39. And when people are being charged by the hour for travel time to work on their houses or their plumbing or their electricity, not by the mile, but by the travel time, that's starting to really cost your citizens. And so, you know, going into your EOTC meeting later this month and with your own budget season coming up, I would really strongly encourage the council to really reread the Aspen Institute mobility study and take a shot at some of the low-hanging fruit, like funding HOV enforcement next summer. So perhaps we have a little relief from the congestion and traffic in town, and look for some other alternatives. You know, we were told the EOTC half penny could not be used to fund HOV enforcement, so it would have to be out of general funds. And similar, I don't think the half penny will be available to fund a new EIS, but you could ask the county attorney in advance on that one, so we don't have to wait till March 24th to find out. But it really doesn't seem to be a transportation measure the same way HOV enforcement wasn't. And as we do move forward with the letter that they have sent you, I thought it was very thorough. I like the final response that they said that they thought Jacobs has prepared excellent work products to inform the city council's deliberations and to advise the city of available options. I would note they did not say it is sufficient work for CDOT to make a decision or for the feds to make a decision in an EIS, because they are acknowledging the likely ratings that some of the alternatives you have proposed might receive. But I'd imagine the additional work that will be done or need to be done by an independent party, which Jefferson was not contracted for, such as valley growth, population, visitation growth, community workforce needs, and of course, where everything will go. So I'd like you to really succeed with this and move it forward quickly. It's been quite a while since you took office, and certainly even longer since that Biden infrastructure money started being spread throughout the state, but not in Aspen. Thank you very much.
Thanks, Rachel. Other members of the public for public comment this evening?
Hi there. I'm Francis Stuckins. I've been a resident in Aspen, Colorado for 38 years. Hi there. I'm responding to what I read in the paper today about a survey that was done about the effectiveness of city government, and that 3,500 surveys went out and only 8% got responded to. That's 280 people out of 3,500. I did the math. I responded to the survey, and I gave high marks on every aspect, except for, you know, what can we do about transportation. I think Rachel addressed that, and you're doing the best that you can. And I just wanted to say thank you I think you're very effective, and that if there's 5 on city council, then you have a good chance to discuss everything and be able to make a good decision, even if everyone doesn't agree. So I'm here to give you kudos, and I'm not going to talk about a marijuana consumption lounge today or bags or anything like that. But thanks again for the job that you're all doing, and for making it clear that we have a voice too as citizens and voters. So thanks again.
Thank you.
Francis.
Other public comment this evening? Tony?
Good evening, everyone. For the record, my name is Toni Kronberg, and it's incredible how fast decades fly by. But when Judge Peterson, when I first moved to town, that was one of the first jobs that I had, was working in the law offices called the Wheeler Square Law Offices. So I've had firsthand experience of how wonderful Brooke is, and I'm really pleased that we're going to have September 24th as the Brooke Peterson Day, and hopefully that means everyone will have the day off on that day. Otherwise, we can have a really big party. And if Brooke and Carol are not traveling, they'll definitely be the honorees. So also, in the very last item I think they're going to talk about today is the letter that you received from CDOT, and I definitely support reopening the EIS and the record of decision so that we can definitely come up with a solution that will work. I think we're all aware of the fact that the preferred alternative doesn't have enough roadway to handle the amount of cars that we currently have right now, and that there are other solutions that were never looked at or were screened that could be undertaken. And then in anticipation of the October 24th EOTC meeting, I think I've mentioned to you that I've started collecting signatures to show support for the EOTC, Aspen, Snowmass, and Pitkin County to approve the first part of a feasibility study for what we're calling the Aspen Highway 82 Sky Cab aerial connection between Ruby Park, downtown Aspen, that stops off at Buttermilk, connecting to the lumberyard housing, the airport. It goes to Brush Creek Park and Ride, and then from Brush Creek Park and Ride, it would go to Snowmass, the rec center, town center, Base Village, and if we can, the mall. And there would be also a lake to Highlands. And the purpose of the feasibility study is to ensure that the corridors that we marked about 15 years ago is still open. And then I've been attending a lot of the markets recently, asking people their opinion on the Sky Cab. And there's one tenant that's come through, and a lot of people have asked if somehow the council could speak to CDOT to see if we could have an emergency order so that the 2 lanes coming out of the roundabout can be opened up. Yesterday, it took 45 minutes to go from the courthouse to the Hickory House. By the time you got to the roundabout, 20 cars were backed up to the senior center, and about that same amount were backed up to Highlands. And I think that if you could ask CDOT if we could have an emergency order to open up those 2 lanes so people can get out of town. But thank you so much. I appreciate it. And good luck to Brooke. And Carol.
Thank you,
Thanks,
Tony.
Tony.
Other members of the public for public comment this evening? Seeing none, I'll bring it back to council table. Thank you. Council members' comments this evening? Bill?
Thanks. I wanted to make everyone on council aware that there is a lot of work happening by a group of citizens to create some citizen-initiated ordinances on 2 topics. The first would be increasing the threshold of the percentage of votes required in the community to grant open space. I believe it's at 50% right now. The talk is about increasing it to 60%. And the second topic would be to direct the city council to proceed with work on the existing Castle Creek Bridge before any resources are used for exploring new entrance to Aspen solutions. Both of these would be binding measures. The first would be a charter amendment. The second would be a binding initiative. I'm willing to be very active in participating in that effort to gather those signatures, and I have a lot of confidence that between this group and myself, we can get this done. So I wanted to give each of you an opportunity, and you certainly don't need to respond tonight, but I want to give each of you an opportunity to contemplate whether you'd like to be involved in modeling the outcome of what happens there, or whether you'd like the electorate to determine the outcome on both of those matters. That's it for me. Thanks.
Thanks, Bill. Other comments? John, anything this evening?
Nothing tonight.
Ward?
No comments.
Okay. I have a few items to go over. Let's see. First, a couple of traffic impacts that are ahead for motorists. We want to let motorists know that there are 2 projects that will impact traffic this week and heading into next month. We have the Castle Creek Bridge. There is an inspection tomorrow, so there will be a 1-lane closure on the Castle Creek Bridge. That is between 9:30 a.m. and 1:30 p.m. So your morning commute will definitely be impacted a bit there. I recommend, if you can, leaving a little early. Try to get through there before they go to the 1-lane closure. This is the routine inspection for every 2 years to understand the condition of various components of the bridge that contribute to its overall rating. The rating is used for future planning purposes. The inspection is crucial to keep the bridge safe for the traveling public. Results from this year's inspection are anticipated in November. Another area of concern for travelers is Mill Street Bridge work that's being done. Repair work on the Mill Street Bridge continues. The project follows a comprehensive survey conducted earlier this year. It identified a bridge joint needing repair. That work is scheduled from 7 a.m. to 5:30 p.m. Monday through Thursday for the next few weeks. It was brought up about a letter in response from CDOT. The city has received a response from CDOT to its inquiry about the process to start the dialogue and how to replace the Castle Creek Bridge on its current alignment in either 2- or 3-lane configuration, and to understand the process to consider a new split shot alignment through the Maroon open space and the replacement of the existing bridge. That letter is available to the public. It is in an information-only memo, but if you would like to see it, it is posted at aspen.gov. You would go under the Government tab and then City Council and Agendas for the CDOT letter. We have got another mixer with our APD, Donuts with the Cops. It's true, cops do enjoy donuts. October 9th, if you didn't get a chance earlier this summer to satisfy your sweet tooth and talk shop with our local cops, you have another opportunity. The Aspen Police Department invites the community to gather on Wednesday, October 9th, for free donuts and chat with local police and community resource officers. Again, Donuts with the Cops will be held from 8 to 10 a.m. in front of the APD located right there on Main Street. This annual event is a little bit of a do-over. The one in July, we had a little malfunction over at the cart, so we're going to fire it back up and get everybody the donuts and caffeine that they're looking for. But there's also another event later that day. It's an event that you don't want to miss. It's crucial for you and your loved one's survival in case of emergency. From 5:30 to 7:30 p.m. also on October 9th, City of Aspen, in collaboration with Pitkin County Office of Emergency Management and Aspen Fire, will host its second annual emergency preparedness event. This year's title is Ready to Rescue Emergency Preparedness for Caregivers. The community gathering will focus on providing essential emergency preparedness information for caregivers responsible for children, elderly loved ones, individuals with disabilities, and your pets. Again, that's Ready to Rescue, and that is October 9th, 5:30 to 7:30 p.m. That'll be here in Pearl Pass in City Hall. For me, I wanted to just read a couple of comments. Just to clarify a little bit about what's going on with the Castle Creek Bridge, tomorrow is that biannual inspection for the Castle Creek Bridge. That report comes back to us in November. You know, this council's shared priority is to make sure that the existing bridge continues in safe operation without weight restrictions or closures while we plan the replacement of that bridge and or a new bridge in an alternate location. This is a state highway. There is a process to get bridge replacement and roadway improvements, both for the funding and for the scheduling. The ROD, the Record of Decision, and the preferred alternative were in preparation for light rail from Glenwood to Aspen, but it was not realized and conditions have changed. The original ROD preferred alternative has been modified to include the light rail corridor, 2 bus lanes, and 2 general traffic lanes. The citizens of Aspen have expressed disinterest in the recorded preferred alternative that includes 4 or 5 lanes of traffic across public open space, perhaps with a 400-foot excavated and covered tunnel, removal of a cabin, impacts to a neighborhood, and a 4-way traffic light at 7th and Main, but without a plan for that light rail. With these change conditions, there are other alternatives that deserve evaluation that can meet our transit needs and goals and community values and character while avoiding the negative impacts that the preferred alternative contained. We are getting started on the state process for alternatives evaluations, and we will be engaging the community for their preferences as well. Obviously, if the report from the Castle Creek Bridge comes back that there is necessary work now, we will engage in that. But we do not own that bridge. We will work in conjunction with CDOT, our state partners on that bridge. Bill will talk. I'll think a little bit about your putting forth what you're talking about with the community and see if there's an avenue there for any assistance or not. With that, we look to agenda amendments. I didn't see any on tonight's, and we get to city manager's comments. Welcome back, Sarah.
Thank you. I have no comments this evening.
Any board reports that'd like to be shared this evening? John?
Yeah, I've got one from Nordic Council last week. Spring Gulch improvements, we got an update on that. Estimate of 20,000 yearly users, which breaks down to 250 people per day on weekdays and around 450 a day on weekends. The big news is Nordic Council reached an agreement with the Meadowwood subdivision. There's a question of whether that trail was going to be open to the public this year, but a 3-year agreement was made, and that's great news for the community and everybody that uses the trails out there. Snowmaking, there was a successful site visit by the SE group in August. They're developing options for different track layouts, sprints, and a 3.2K track. So far, no major red flags. Water supply might be the biggest issue, because obviously water is in short supply, especially at that time of year. Fees could push 6 figures. Also, bylaws were updated and term limits added, and again, this winter is going to be the 40th anniversary of Nordic Council and the trail system, and there's going to be a celebration. We are discussing where and when that's going to happen. And that's it.
Thank you very much. On to our consent calendar this evening. Consent calendar tonight is resolution number 94, fleet replacement, procurement of 2 CAT motor graders. Resolution 110, contract with Economic and Planning Systems for a rental rate and affordability study for APCHA properties. Resolution 115, Maroon Creek Multi-Use Trail Additional Spending Authority Request and Change Order Approval. Resolution 116, to rescind Stage 1 water shortage declaration. Resolution 117 and 118, these are emergency procurement, Mill Street Bridge maintenance, critical repairs. Resolution number 119, this will be appointing Ted Garden-Schwartz as presiding municipal judge. Resolution number 120, the Lewis Ice Arena Evaporative Condenser Replacement Supply and Services Agreement. We have a board appointment for Kids First that we will pull and discuss in a moment, and the draft minutes of September 3rd and 10th. Are there any items that council members wish to pull for further discussion? Yes.
115, please. 116, just for a quick comment, and then, as you mentioned, 6H. The board appointments.
115, 116, okay.
Yep, thanks.
Yep. Any others? 115 is the Maroon Creek Multi-Use Trail.
Good evening, Mr. Mayor and City Council. My name is Matt Kuhn, Parks and Open Space Director. I'm joined with Austin Weiss, Parks and Recreation Director, as well as John Spees, Senior Open Space and Natural Resource Manager. If I could, I'd like to touch base on a few things before questions. Great. I think it goes without saying this is absolutely the last place we'd want to be right now at this stage in the project, coming back and asking for additional spending authority. But I did want to touch on a few additional points on this project for consideration. And I just wanted to real quick look back, and at the direction of City Council in November of 2021, we began working diligently on this project to accelerate its timeline and complete the project and the last missing link in the Maroon Creek Valley. And I think it's really important that we just take a quick moment and celebrate the success that we're at this juncture with probably 2/3 of the trail open to the public tonight, just a little bit more to go. And it really is because of both this council's support and the community's support since 2021 that we have this wonderful new trail and community connection. Just yesterday during a walkthrough with Pickens County Open Space and Trails staff, we watched as dozens of walkers, runners, and cyclists hopped on the trail at the roundabout, connected up to the Maroon Creek Valley. And our early observations are seeing that this trail's use is by a variety of users. Today I saw walkers and we-cycles and runners, a whole spectrum. The change order and budget authority request in front of you today are a reflection of the uncertainty and the risks that exist in this scale of civil site construction. Whenever we put a shovel in the ground, or in this case, we've had multiple excavators up there for months on end, we're gonna find unknowns, and those changes are subject to cost escalation in this contract. The contract with Gould Construction was approved by City Council around 13 months ago, and it was based on a design and our known investigation into the site at that time. Our geotechnical survey showed that the project area consisted of around 6 inches of topsoil across the trail alignment based on our geotech sites. As construction picked up this May and June, we found that there were significant deviations in those topsoil assumptions, and as a result, extra material was needed to be removed from the site. And as the memo states, this causes a trickle-down effect in terms of us needing to then replace with structural material. Generally in this department, we believe in doing things right the first time. And while this trail could have been built on that unsuitable material, over the long run, that trail will crack, degrade, and become a costly and time-consuming effort. It's worth noting that during the design phase of the project, we looked at many alternatives and means and methods for construction, as well as locations of the trail. The result of those efforts, we feel, put this trail in the Goldilocks zone, meaning we could use, where was my Yep. Meaning we could use alternative building approaches such as soil nails to reduce our impact of the project. And those would have either significantly added to the cost or to the project construction durations. We've also balanced and prioritized user experience. An investment of this magnitude should aim to provide a comfortable user experience. And honestly, that is what makes our trail system consistently ranked at the top. Widening and building alongside the road was also another consideration. And while that could have likely accomplished a connection, it would not be a safe experience for a variety of users, and it would be a significant challenge to maintain in the winter months for year-round use, and arguably not maintainable in the winter. Our community year in and year out places trails as the highest priority and the most valued assets of everything we do in the Parks and Open Space Department. This investment by council and the community supports that vision. And while this is a significant investment, other recent projects are similarly priced. Looking back at the Castle Creek and Hallam Street improvements that happened in 2018, those had a budget of $5 million. In today's construction environment, that's over $7 million. And the Castle Creek Trail to the Music School, built in 2020, was $4 million, and that's also 5.1 in today's dollars. We're looking forward, in closing, to a joint dedication of this trail with a variety of partners that have helped us get this to fruition. We're eyeing October 29th at 4 p.m. with partners from the county and the school district, and we're really looking forward to inviting you all to that as well. With that, we're happy to answer any questions you have on this change order and the topic at hand, and we'll leave it to you.
Thanks.
I'm going to start. I'll start with the good part. I rode the trail today, and it's really nice. Sweet. Looks good, and I was so excited for the completion of this project after watching it all summer. So kudos on a nice project. I was super frustrated to see the packet come out and have to have this conversation just like you were. And here are my concerns. Number one is I take my role as a fiduciary to the City of Aspen citizens seriously, and this just feels irresponsible. I mean, I was uncomfortable with what this trail cost initially, and this second change order is just putting it over the top. I don't like that feeling. Secondly, the trail's done, more or less. It feels like maybe we're in the last 10% of the race. So if it feels like you've already exceeded your spending authority, and what happens if we say no to you? That doesn't feel right to me. I don't think that's appropriate. I don't think that's the way things are meant to go. And so I'd really like your response to that second part, because that, you know, especially after riding it today and seeing where things lie, I mean, we can't just not pay the bill. So we don't really have feasible alternatives, and that's not the way this process is supposed to go, from my understanding. So that's my comment and my question.
Sure. The second question first. The way this project is structured with the contract, we're typically receiving our invoices anywhere from 1 to 2 months post-construction. As those projects as the work is unfolding, Gould is tracking all of the line items, and this contract has a tremendous amount of detail based on the design, and that's one of the really important things that I touched on previously, is Gould provided a bid. They were with us from start to finish in the last stages of design, and they bid based on the known quantities that we had in the bid tab. And as those deviated, we were tracking those. We are hopeful that we're going to continue to see some savings on certain line items. And John and our construction manager on the site and the Gould team have spent countless hours tracking those and trying to forecast where we're going to land. So we are a little bit ahead in asking for this money. because the books haven't closed yet. But we anticipate, and where we're looking and what we're forecasting on for the remainder of the project is that we are going to need that extra funding. And so our spending authority is not depleted at this juncture. However, based on our pay apps that we've received in July and August, it's looking like we're going to need, and we've forecasted what is the remaining costs. I do want to highlight there's possible savings. It's probably in the order of $250,000. We don't know yet, and we don't want to account for that in this final number, but we're hopeful that we're spending less than what we're asking for in this final tranche. So, in short, our pay apps as we receive them are 2 to 3 months behind. And that's why what we're paying right now is based on June and July's pay apps.
Yeah, I appreciate the explanation, and based on my own experience, I truly understand that. But it still feels late. I mean, these soil conditions have been known to you for a long time. The risk of overspend has been known to you for a long time. There's not much that we can do differently. The alternatives for us are weak, and that's not the way this is supposed to work. So it doesn't change my opinion. I appreciate the explanation, and I do truly understand it. And that, you know, you're talking about saving $250 of an additional $750, right? What was the number? 770?
790.
790. Thank you. We're not talking about saving $250 off the already change ordered amount. So this is a theoretical savings of an yet again increased amount.
We hear you. Thanks.
Go ahead. Thanks.
This is really disappointing for me. I mean, I'm totally appreciative of the trail. It's a beautiful trail, and I appreciate all the work that John, Matt, and Austin have done over the years, but this is a huge disappointment. The last time we had a change order, I think it was $320,000 for exactly the same thing, and it, as Bill's pointed out, it appears to me as though we're being asked to fund something for work that's been already done.
The $320,000 change order was on stormwater infrastructure. It was not on soil conditions and traffic control, which is what this one is for. It has to do with timing on that first change order, and I want to highlight that because it is a different case. When we contracted with Gould 13 months ago, there were certain elements of the design packet that were not completed. And so as we worked through the building permit and we got requirements from the county and from the city that required changes to our stormwater plan from what was bid, those were added in April. These have been post that and are due to unknown risks associated with subsurface conditions.
It seems to me as though the geotechnical survey was a failure. That you drilled these holes and you proceeded with the work, and the geotechnical survey said you're fine, and it wasn't fine. So I'm concerned with whoever it was that conducted that geotechnical survey, and question the continued use of that contractor in the future based upon failure on this instance. What was the full budget allotment for this project, and what is the cost to this point with this additional $790,000?
Do you have those numbers off the top of your head there?
Well, yeah, total project. Total project costs, $7,572,000 were the total appropriations for the project. That includes design, testing, project management, and construction.
7.5 was what the total budget was,
Correct.
and what's the spending at now with all the change orders?
I don't have that number currently. I think I shouldn't hypothesize, but I can get that to you.
Okay. You know, on the one hand, I'm so appreciative of the added security it gives to the school district of having the trail not go through the campus. And it's a beautiful trail, but I'm hugely disappointed with how it just always seems to me as though nothing comes in as what is bid, and that the project's not over until the contingencies have all been spent, and change orders have been issued and approved. So I don't know where we are on this. It's work that's been done. We have to pay for it, but I just have to register how disappointed I am in how this went down.
If I can just respond briefly, our department operates and performs a lot of capital work. I think in general, almost all of our capital projects, once they're contracted, have been executed within budget. This is an exception, and it's substantial. I agree with you. And as I said, this is not how we typically run our projects. What this highlights for us, and one of the big lessons learned that you highlight, is geotech. When we're constructing a mile-long trail, unless we're surveying every 20 feet with 4-inch bore samples, which are substantially expensive for us to perform, we are taking on a fair amount of risk. And I do think as we structure future contracts, we're going to account for a larger portfolio of funds to handle that kind of unknown site conditions. And I think that's a really important thing for us is even with the best geotech, we're going to miss boulders. In this glacial till environment, there's going to be pockets of deep soil. There's going to be rocks that need to be removed. And I think for us, we're going to start to focus and put more effort on how much contingency we place for the subsurface conditions, which are a tremendous variable.
You know, and I acknowledge the subsurface anomalies. When we started building this building, there was a huge change order because old ties and all kinds of other stuff was thrown into the ground, and when it was being excavated, it had to be mitigated. So I'm aware of those anomalies in our subsoil, but again, it hurts to spend another $790 on this.
John?
Yeah, I would agree with some of the concerns Bill and Ward have raised here. And it is really unfortunate. But I also understand that a lot of these things are unforeseen. I mean, it's hard to see what's underground. Anyway, I'm hoping that we can all learn something from this and move forward. But I will say this is a fantastic new trail, links the Highlands to the rest of our system, and I look forward to being able to do the same out to the Brush Creek Park and Ride. Thanks for your hard work.
Thanks.
Yeah, I just wanted to echo the thanks. Parks and Rec, you guys, and Open Space, you guys do some of the best work here in the city, and one of the things that I want to just acknowledge is the tangible notice that we feel from trails like this and the new pickleball courts that are coming. So as unfortunate it is to spend an extra $790,000, I know you guys are great stewards of the money that you have in your budget, and I'm just so thankful that we actually, as a council, have something to point to as look at this new trail, look at these new pickleball courts, because I don't feel like we have enough of those tangible wins. So just wanted to thank you for that. Thanks.
Thanks, Sam. Bill?
One more thing, if you don't mind. Yeah, I too get it, and I get the unforeseen conditions, and I've experienced them myself personally in my own projects, and I sympathize with that. My bigger issue here is what really happens if we don't approve this? You know, we have not been provided an opportunity to make the decision as a council that we should be provided, and that's not a precedent that I want to set in the future. So we need to be more proactive when these issues come up, and not reactive, because I'd like you to answer, what happens if we say no on this?
You'll have a few options. If you say no, you could postpone or eliminate the construction of that portion of the trail from the project. We would return the site back to original conditions. You will have impacts to the ARC from that, and access to the ARC most likely. You have the option to direct us to build it on an unimproved subsurface. If we need to go that route, we will. We won't recommend it. It's why we have the problems we have on Main Street. We have a failing subsurface underneath the state highway. I agree with the approach that the department has taken, that we're going to build it right, even if it costs more now, because to fix it later is going to cost even more. And while it's an unfortunate situation that the geotechnical didn't catch this, you'll see this across my recommendations for the 2025 budget, significant increases in contingencies, because it is becoming very unpredictable on many projects for these unforeseen circumstances between site conditions and the inflationary market that we're dealing with in the trades right now. Council went into this and made a tough decision 13 months ago when approving this contract that it was going to be done without full design work done. And you chose to move forward because you felt it was a top priority for the community, and particularly the school campus, to get this done. You asked us to go find funding partners for it. We tried to find them. They were not, our partners were not in a place to be significant funding partners, particularly the school district was unable to do that for us. I get it. It doesn't feel good, but I would recommend that this project be built to our standards that we would require any trail to be built with, which includes this work before you tonight. Thank you.
So, Sarah, I just asked about the alternatives if we don't approve it. You talked about interrupting the construction of the trail. The trail's done.
This portion is not completely done.
This portion is done, Sarah. I wrote it today. I don't think either you don't understand or you're not aware of the status of construction, but the trail's finished. So that's my fundamental issue here, is that we are not afforded the opportunity to make these tough decisions when we should be making those tough decisions. It's too late. So that's not accurate what you just said. I'm sorry. And I also don't remember being adequately informed that design was not completed on this trail when we approved this 13 months ago. I don't know if any of the four of you remember differently, but that's news to me that that was adequately presented to us at that time.
Yeah, we were really clear that this was not a GMP contract when we brought it forward. We were very clear about that.
Isn't it a GMP contract?
It is a GMP contract. However,
no, this portion.
The contract with Gould is a GMP contract.
So my apologies, then I have this mixed up with earlier work.
But what I want to highlight is that the design that we bid with Gould changed as a result of the building permit application process, which I'm sure you're well aware. As you go through the building permit, you get revisions. So we already had a contractor on the hook prior to building permit issuance. That's what drove the first change order. The question about not having an option, it ties a little bit to the timeline back to pay apps. As staff, as project managers, we made the decisions to proceed with dealing with pockets of deep topsoil as they arose, knowing that we weren't going to have the accounting done for quite some time. And as this trickled in, it accumulated. But we had to essentially try our best to keep the timeline. If we were to stop work on this and then calculate the quantities, we wouldn't know the quantities of excess material until those were excavated. And so it's this cumulative trickling approach that became a big challenge. It wasn't like we had an x-ray and we were able to calculate that there was 250,000 cubic yards of excess topsoil on the project and then come to council and ask for the extra budget on that. It accumulated as we came to those and dealt with each issue, correcting it with suitable structural material. It would have been awesome to get in front of you in July with this as a heads up, but we didn't have those unit quantities until start of September when we prepared this memo. And I do want to highlight that certain elements of the contract we're not able to pause construction and not delay the timeline and have negative cost escalations associated with that. So when we have a pocket of 7-foot deep topsoil, we're gonna work through that, quantify it, and then look at our whole books holistically.
Again, I appreciate it and I understand it, but we're being blindsided by this. There was no info-only memo, there was no email, there was no potential of this issue, there was no, hey guys, we don't know what the quantities are gonna be yet, but we think this may bust the budget. It's just not great communication and it's not great project management, guys. We are the clients and we're being totally blindsided by it.
I'll take responsibility for that, and if there's any other questions for staff, I'm happy to address those.
Would you like this item pulled?
I would. Thanks.
Ward?
Yeah, final comment on Gould. I think Gould was the contractor for the Hallam improvement, and they were a good partner with that. They left the site during the rush season and came back and completed it after the busy season. I think in my experience, they've been a good partner in the past, and it's just really unfortunate the way that this went down. Thank you.
All right. Thanks. Thank you, guys. The next item for discussion is resolution number 116. Rescinding stage 1 water shortage declaration.
Just a super quick comment here. I wanted to give you kudos for being proactive, acknowledging that conditions have changed, not getting entrenched with something that isn't a issue at the moment when it has been an issue in the past. I think far too often in this community and a lot of communities, we react to something that has happened and then we don't look back to see what the results actually are. And so I think this is just a great example of being proactive, adjusting to the conditions at hand at the moment, and thank you.
Thanks.
Other comments or questions? Thank you, guys.
Great work.
And that'll bring us to our discussion of Kids First board appointments. We had 3 applicants for this alternate seat on Kids First Board. And that was Ramona Bruland, we had Emily Kolb, and we had Allie. Thank you, Barry. We had to schedule several different rounds of interviews for this, and the last interviews that we had, it was apparent that all 3 of these candidates were really great. What I would like to put forward to this council, Emily. I'd like to nominate Emily. She not only was great in her responses in her interview, but she made time for the interviews that she was called to, and just really showed well. Even some of the other applicants were complimentary about some of her ideas and the energy that she was bringing to that. So I'd start off with a nomination and see if there's support for Emily. And if not, then we will consider others.
I would second that.
All right.
I would support Emily Colby, absolutely.
So we have checking in, we have a nomination, a second for Emily for appointment to the Kids First Board. Comments?
Yeah, comments. 3 outstanding
Yeah.
applicants with obvious dedication to early childhood education. I think that it's important, and I asked the question if you all were dedicated to this, and I know it took 3 rounds to get everybody to respond, and Emily was there from the get-go. So 3 outstanding applicants.
Absolutely. So if we have a motion and a second for appointment of Emily Kolb to the Kids First Board, could we, we'll need a roll call vote for that.
I'd just like to make one comment, is that I wish that this were done in some kind of ranked choice vote fashion so that everyone's preferences could be weighted. Again, 3 wonderful candidates, super appreciative of everyone's interest. I personally prefer someone else other than Emily, but I'm not really getting an opportunity to have that preference considered.
Excuse me, but I think we have considered all 3 of these, and I understand your, if you wish to voice your support for that other candidate for the record, I'm sure it would be appreciated.
Well, I prefer Ramona, but I'm just not sure this is the best way to go about it. I think that there's ways to do some kind of ranked choice preference or something in the future. So this is more a comment for future situations such as this, but that's my preference.
Okay. Could we have a roll call vote for that appointment?
Counselor Doyle. Counselor Doyle.
Yes.
Counselor Guth.
No.
Counselor Howenstein.
Yes?
Counselor Rose.
Yes.
Mayor Tory.
Yes. And again, all 3 candidates are fantastic, and when we had our last interview with them, I was sure to encourage whoever does not get this alternate seat to be looking for our next round of interviews, because there will be 2 seats available, Kids First, next year. So hopefully that they will stay in contact. Okay, with that, we had a request. So, Bill, if you would like to make a motion for Resolution 115, you don't have to vote in the affirmative for it.
Sure, I'll make a motion for approval of Resolution 115 and not the rest of the consent calendar.
Thank you. We have a motion.
Second.
Thank you. Could we have a roll call vote for Resolution number 115, please?
Counselor Doyle.
Yes.
Counselor Guth.
No.
Counselor Howenstein.
Yes?
Counselor Rose.
Yes.
Mayor Tory.
Yes. And then with that, I could take a motion for the remainder of the consent calendar.
I
I'll make
move
a
we
motion.
adopt the consent calendar.
Seconded.
Thank you. A motion and a second. Any further discussion? Could we have a roll call vote for the remainder of the consent calendar, please?
Counselor Doyle.
Yes.
Counselor Guth.
Yes.
Counselor Howenstein.
Yes?
Counselor Rose.
Yes.
Mayor Tory.
Yes. All right. Thank you all for being here for consent calendar this evening.
Yeah, would like to. Thanks.
Our thanks to Ted Garden-Shorts, who is here with that consent calendar. Ted will be our presiding municipal judge. That'll bring us down to public hearings. Our public hearing this evening is on ordinance number 15. This is the non-discrimination ordinance. Thank you again, Brooke.
Thanks, Brooke.
Good afternoon, Council. Kate Johnson from the City Attorney's Office. And I will be presenting with Melissa Farrell. Thank you, Kate, Administrative Services Director. Give me one moment. This bar up. Yeah. Right. Great. Thank you. Mr. True may join us on occasion as well as we present. So for second reading tonight, we're here to present at a more granular level at this juncture the proposed non-discrimination ordinance. We also plan on addressing your feedback provided to this point in our presentation. So we wanted to start with providing some more context and background of where we ended up where we're at today. We wanted to go over the legal landscape with a general overview of some historical context, more than recognizing our groundbreaking 1977 ordinance. We have some more historical context related to federal and state laws and the legal landscape for prohibiting discrimination based on protected classes in the areas of employment, housing, and public accommodations. And those are the same areas that address our 1977 ordinance. Really, what we're providing you are a few examples. So you have CATA, the Colorado Anti-Discrimination Act, to state law. It was amended in 2021 to prohibit discrimination on the basis of gender identity and gender expression. So where we're headed with these examples that are in front of you in the PowerPoint, the U.S. Supreme Court and the interpretation of Title VII, is that these laws have evolved, and we're working towards aligning our local law with where federal and state laws are at. And that includes expanding our protected classes and those definitions, as well as addressing disparate impact and disparate treatment. So as a reminder, back in 1977, discriminatory laws were interpreted to not provide protections in such areas as sexual orientation, gender identity, gender expression, and genetic information, which created a need for the city of Aspen, back in the day, to launch the state's first non-discrimination law. Today, this legal landscape has evolved, and federal and state laws that prohibit discrimination based on protected classes are interpreted to typically cover these areas. In summary, the legal landscape has evolved, and the city of Aspen is now mirroring and incorporating these protected classes into one law in the areas of employment, housing, and public accommodations. Another example would be ADA. So I believe in 2008, it was amended to include perceived disabilities, perceived physical and mental disabilities, in addition to disabilities. And that's another example of expansions of discriminatory laws and protected classes from a federal and state perspective. And that is consistent with where we're heading with the city's non-discrimination ordinance. So again, as a reminder, your general changes include strengthening and contemporizing language for inclusivity, expansion of protected classes, alignment with relevant federal and state laws, and addition of elements of proof, which Kate will elaborate on, which is, that section is similar to relevant federal and state laws, and adding a level of consistency with fines. So the why, we were asked that question previously. It really represents a public commitment to the concepts of inclusivity and equity within our community. It's also a commitment by the city of Aspen to enforce the ordinance through civil action when appropriate. It represents our community values. It provides a centralized and local avenue to pursue. It's a streamlined option, and it provides a choice. With that, I'll turn it over to Kate. I just want to highlight on that, at the state level, we have the State Civil Rights Division. So if anybody wants to report discrimination, and I would note that the state's discrimination laws will mirror what we are proposing here today as far as the protected classes. So there is an avenue at the state, but unlike here where we often meet with people face to face and hear their stories at a local level, at a state level, there's an entire process to go through. So this provides a local option where you can come into our office, talk to us, and I think we're just better situated to sort of investigate at a local level a claim.
At the federal level, you have the Civil Rights Division. Again, it requires the filing of a form, generally online, and it's handled by the Department of Justice. So both of those avenues can be daunting to somebody who may never have had any experience with the judicial system or the law. This provides somebody they can call locally and ask for assistance. So the protected classes, these are stated in the definition of discrimination in Ordinance 15 that's before you. They include race, creed, color, sex, affectional or sexual orientation. Those were always part of this ordinance. They have been since 1977. We added gender identity, gender expression. Both were added in 2021 to the Colorado laws. Genetic characteristics. We're hearing a lot about this lately, especially with respect to genetic testing and some insurance, sometimes insurance decisions. Marital status, religion, religious expression, national origin, ancestry, pregnancy, parenthood, custody of a minor child. Those familial associations have been added, consistent with state housing regulations for non-discrimination requirements. And then mental or physical disability. We had disability, but not mental or physical. We broadened that to ensure that mental disabilities are covered. Sources of income, immigration status, and I would note that Colorado, in addition to CATA, added immigration status to many of its employment requirements and its public benefit requirements. You can no longer make decisions based upon immigration status in those areas in the state of Colorado. Age, which was always part of this, familial responsibility or political affiliation of such individual. And here's one that is unique to us. Individuals, friends, or associates. We live in a small town. Many of you may have been subject to sort of being the implication that because your friends are associated with somebody, you may share certain beliefs or ideas. And we want to be sure that discrimination does not happen simply because you know somebody are associated with somebody. So that's unique to Aspen. Any questions on those areas? Some of these have been defined, so if you want more definition, we have provided definition as part of the statute on some of these terms. Okay, thank you. So we also added an elements of proof addition, and this I think is important for some of your prior discussions. The essential elements of proof, first of all, I want to preface this by saying that the characteristics of a victim are not necessary to prove discrimination. So that takes that sort of off the table. It can be introduced, it's just not a necessary element of proof. The essential elements of proof shall be of, if we can prove discriminatory intent, those can be generally through words or writings or conduct, communications is generally how you prove intent, or disparate treatment. Again, those are generally through words or conduct, or disparate impact. And we have to show not only that there was disparate treatment or disparate impact, but that there was a nexus between the intent or the treatment or the impact and the action or refusal to act in either housing decisions, employment decisions, or public benefit decisions. So again, we're limiting this to those three areas, but there has to be a nexus between the act, whether that be a failure to act or the decision to grant or do something, and then this either proof of an intent or that there was in fact disparate treatment or disparate impact. Now, my office, I think, was asked to review by a couple council members concerns that inadvertent acts of discrimination may subject an actor who unknowingly discriminates to punishment in both the criminal law and the civil law. While unlikely, it is, I think we have to recognize it's possible that that a discriminatory act may be completely unintentional. But nonetheless, what we're focusing on with this ordinance on is that discrimination did occur. Our goal in drafting this was to prohibit discrimination in these areas. Therefore, we looked at whether or not carving out an exception would be possible and still meet our goals. And really what we're looking at here is somebody who comes in and claims they did not know. If you allow an exception or an exception to somebody who claims they did not know, we feel it is our opinion that you would completely undermine the impact and the effectiveness of the ordinance. Because the fact is, if we can prove the discrimination occurred and that there was no legitimate reason for that decision but for the discrimination, discrimination occurred. And our goal is to stop that. And so while I understand they didn't know, we have to recognize that may happen, and that may be true. I think our elements of proof and your sentencing provisions, at least with municipal code, and the power you give the city attorney's office through this will allow us to sort those out and treat those accordingly. And I think you have to have faith that the judiciary and our office will do that. I will note that Judge Peterson was in here, and most of the cases Judge Peterson deals with are the parking violations. And I bet he can't tell you how many times he heard, "I didn't know." Unfortunately, they still violated the law, and they were punished accordingly. He certainly took it into account. He let those people speak, and I don't see where that wouldn't happen in this case. I will say that our elements of proof require both the city attorney's office and the judiciary to hear whether or not there was intent, to make a factual determination whether or not there was intent. And so that will always be part of this analysis. And to the extent they didn't know happens to be true and we can't prove otherwise, I do think that will, one, go into the decision whether the city attorney's office pursues civil remedies allowed under this law, and whether or not we even prosecute a case. So I often give an example, when our discussions here, we've talked a little bit about this. In a CLE I attended, they did some data analysis on a judge, and he was inadvertently, he had no knowledge of it, sentencing people of color more harshly than white people. And he didn't know it, and I don't have any reason to question he didn't know it. But I think he would recognize it was still happening, and he needed to take steps to correct that. And I think that's sort of that example of, is it possible that somebody may not know? Yes, it's possible. I think it's unlikely, but it's possible. And I think that the way we've set up the system is it has to go through the city attorney's office first to even decide whether to prosecute. And then even if we were to prosecute and that person says they didn't know and we didn't have any evidence they did know, but we can still prove disparate impact and a nexus between that decision and that impact and no other legitimate reason, that they should still be subject to penalties under this law. Now, if they can come up with a legitimate reason, we may not prove our case, and that could very well happen. But I think we would sort that out in deciding whether or not to take action under this ordinance. So we've thought very hard about that. We've put a lot of time and effort into thinking about that, and we feel that the way this ordinance, the elements of proof, the punishments available, provide enough safeguards that even if the discrimination was inadvertent and non-intentional, that can be addressed accordingly through this process. Does anybody have any questions about the elements of proof? Any concerns? Okay. Examples. We wanted to give you some examples. I think where we see a lot of this is in employment decisions, where you might also see some, and we just did a few, we can talk more about them. Refusal to rent or sell. I think you might see some inadvertent examples in that area. Determining whom to serve or not to serve, and compensation decisions. Now, I have to say, all the facts that went into making these decisions by somebody accused of this will come out in the investigation. But I know Alyssa's dealt with this probably more than I have on an actual real life level, so she had some examples that we thought might be helpful in trying to understand how this would work.
A few examples from a reasonable standard perspective as well, and although it's titled examples of unlawful practices, there are examples of lawful practices where it's part of a job duty or job requirement, so possible caveat around a business necessity or a terminology, a bona fide occupational qualification. So if you have an airline that's requiring flight attendants to be a certain height, as an example, that would be a business necessity and a justified reason to be potentially perceived as discriminatory and a lawful practice. But you have to very much prove that business necessity. And then in terms of, I think this one is interesting as well, disparate impact. You have, think of a relevant physical agility test and for a firefighter or a police officer. There are job duties that require someone to lift X amount of weight as it relates to a fire hose or chasing someone per se. So those are examples of relevant for job duties performed for those positions. And that could be impacting females as one example. Now, are those relevant for an accountant? No. So that's where it could lead to discriminatory, disparate impact. So we're just providing examples so we can begin to connect the dots within these situations.
Yeah. And we talked a lot about examples, so if you, yeah, it's an interesting conversation to have, but I think this at least highlights for employers, there might be a very legitimate reason why they require certain tests. If they provide proof of that, certainly I don't think we would pursue prosecution under this law. We would have to show that it was unnecessary requirement and intended, either intentionally intended to discriminate or had a disparate impact. So I just wanted to walk through generally how this would work if we were asked, if we received a complaint. So under the proposed ordinance, the city attorney's office is responsible for enforcing the ordinance if it's passed. They have 1 year to file from the date of violation, of knowing the violation. We have the option to pursue any or not one or all of these. We can pursue civil remedies, we can pursue criminal remedies, and we can pursue administrative remedies. So for the civil remedies, anyone can file with the city attorney a request to commence a civil action. That can include requests for compensatory damages. That can include injunctions to stop doing something or to do something. Those are generally what we think of when we think of, or temporary restraining orders. I don't know that a restraining order would be a usual necessity in these cases, but it is available to us. We would have 14 days after receiving that request to determine whether we intend to pursue a civil action on that person's behalf, on the victim's behalf. If we determine that there was in fact discrimination as defined in our ordinance, we have to file a civil suit within 30 days. That will go to the district court. And we'll have to state expressly what relief we're requesting. If we choose not to, that individual can go do it on their own. They do not need us to do it. However, if we choose to take it on, they cannot file their own unless we dismiss our civil lawsuit. So there can't be two going on at once. Either we choose to do it on their behalf and we take that on, or if we feel we cannot meet our burden of proof, then they have that option to pursue it on their own. In addition, we can charge them in municipal court. We would issue them a summons and complaint. They would be subject to the same fines and penalties for most violations, which includes a fine of up to $2,650 for each offense or imprisonment of 1 year. I will say I don't see imprisonment of 1 year on a first offense, even being in the realm of consideration. It would have to be extremely egregious. In addition to that, we have this administrative ability, which is to, if they have a business license, permit, franchise, or benefit, we can temporarily or permanently suspend, for instance, their business license if they violated the provisions of this ordinance. They would have the opportunity to appeal that decision to you. So while it would happen administratively, they can appeal any decision of that nature directly to City Council. So those are generally the areas of penalties a violator would face, and again, the city attorney's office is generally tasked with enforcing.
Question?
Yeah, thanks. Firstly, not related to enforcement process. Thank you for the time and thoughtfulness that you put into my concerns about inadvertent discrimination. I appreciate that. Related to the enforcement process, question one is, do other municipalities or the state of Colorado have all three of these avenues available to them under similar laws, civil, criminal, and administrative?
The state generally has the ability to pursue civil remedies and criminal remedies. I can't really speak directly to other municipalities. I haven't looked, but it wouldn't surprise me at all. I think Boulder probably has a very similar scheme as us. And federally, there are these, the Department of Justice has these remedies. Administrative remedies, the permit, license, et cetera, I don't know if other municipalities have done that, but generally in the state world, I don't know that that's available because there again, not all businesses require state permits. In Aspen, if you operate here, you will require a business license under our code.
Understood. So it's, in other words, it's not unusual for various governments to have both civil and criminal options.
That's very
to pursue.
common.
Okay, thanks.
Very common, especially with land use.
In our existing law, in this vein, we have some enforcement processes as well, right, which you're updating.
Very similar. Yep.
Can you talk about, like, how often do we enforce things? What are the past examples of enforcing things? This is more of a curiosity than
Sure.
I'm certainly not challenging
I think
anything.
Mr.
I'm just
True would
curious.
be the best person to answer that question because he's been here longer than me.
I can tell you, since I've been here, since 2007, we've been approached, that I recall, one gentleman who was making a claim of discrimination. He would not sit down with me and discuss his issue. I did look at it as best I could, and we chose not to pursue anything. He did file his own civil action. I can tell you from my experience in private practice that I did, and prior to my time here, did use the law in a situation where my clients claimed wrongful termination because of their sexual orientation. We were able to produce a document that used some very derogatory words about my clients, and we were successful in our wrongful termination claim, and used this law, but that was frankly in 1982, maybe 83.
And then we used it in 2020.
What?
We also utilized this law in 2020 and 2021 for a business that refused services based upon political beliefs. So they were issued a warning that we could pursue this, and they amended their practices after that discussion.
That is correct. I forgot about that, but we did not take any specific action.
Correct. We did not take legal action in that case.
No, I did forget about it. I'm sorry.
Thanks. That's interesting and helpful to understand. And I guess my last question on this would be, like, does the enforcement process as proposed in the new law put significantly more burden on the city to do something when approached? And the reason I ask it is because wrongful dismissal and other discrimination claims in business, as we all know, are commonplace. Both allegations against the government and private employers. This is not unusual, but are you going to need more attorneys to handle this because of how we're changing the enforcement process, and we're going to be inundated with things that we are now obligated to address?
This is not substantially different than our current enforcement language in the 1977 ordinance. I do not think that this is a substantial change of that, so I certainly don't think it will lead to an influx of cases. And often with employment discrimination cases, they're done through the Colorado EEOC
So-
or the Colorado Civil Rights
The Rights Division.
Division. And in fact, again, in my private practice, that's when I had cases like that, I went through that process, not through the city process.
And why would you choose to do it through those processes versus the city process? Assuming you were in private practice representing a client who claims
My
it.
experience with the Civil Rights Division, they have mechanisms, they have quick hearings, they have certain authority and powers to force people into mediations and resolutions, and I had in private practice success with that. And I don't think it'll change that. I think employers and employees recognize, or at least attorneys in that area recognize, that that is a very productive way to go if you feel that there's a employment discrimination case. And again, I had success in private practice in that.
And the EEOC, if they find you have a legitimate claim, will appoint a lawyer to represent you. So as a complainant, if you have a legitimate claim, the law provides that they will assign you a lawyer. And that's I think I think they're, as Mr. True said, they just have a lot more power than in the employment law field. And their sanctions, I think, can be fairly, a lot more heavier than sort of what we have the ability to do at a local level.
There's another aspect of it too, and that's our people wish to pursue remedies and financial remedies in district court that has a lot more power and authority to grant claims for damages and such. And to do that through the employment discrimination under federal or state law, you've got to get a right to sue letter. And you go through that process to be able to take your case to the either federal or state district court. And that's just the process. This does not have that same type of mechanisms that I think would be utilized itself. It may be used in conjunction with some claims, but I don't see it as so much as a private claim that people would use.
Great. And final question, I promise, on this is, does anything in this proposed law require a claimant to choose the venue? So, in other words, do they need to decide whether they're going to do the EEOC or something else or the city, or can they pursue all simultaneously?
I don't think there's anything that would preclude multiple efforts. I think if you file a civil suit because the city is not doing something, the city can prosecute its thing while somebody's going off in a private direction too. But to file a civil suit under our code chances are would be consolidated if they chose any other kind of litigation. But we certainly could pursue our own criminal case under this statute with somebody pursuing civil remedies somewhere else. Nothing would preclude that.
And we're fine with that, right? That's not something that we haven't contemplated, or?
I think we would want to be fine with that, because I think it would be fair if we felt that there was a legitimate discrimination and somebody wanted penalties through a different mechanism. That's up, civil type penalties, that's up to them. We could pursue our criminal charges if we felt it was appropriate.
Thanks.
These are the highlights of the ordinance that we felt wanted to make you aware of in your discussions. I don't have anything else. I don't think we have, oh, sorry. I'm sorry. Outcomes. I'll let you talk about outcomes.
Okay, great. And thank you for your questions. Those are really great questions and thorough. Expected outcomes. So just in summary, we're really focused on continuing to safeguard protected classes from discrimination in those categories we mentioned. Updating our ordinance, it really mirrors state and most federal laws prohibiting discrimination. We continue to be an enforcing agency, and we're informing our community through ongoing education of prohibited discrimination. We are looking at, within the window here before the implementation, adding pages to our website, including resources and information in a complaint form in English and Spanish. So that'll continue on if this ordinance is approved. And then continue reinforcement of our community values. This inclusivity came up as a focus area from our community survey last night. And this is an example of work that's already been happening to move some of those scores and projects forward. And then in conclusion, implementation would be effective on October 25th, which is 30 days from date of passage if approved tonight.
Thank you.
Thank you.
Any other questions? This is a public hearing for ordinance number 15, non-discrimination ordinance. If there's any members of the public that wish to address ordinance number 15. Seeing none, I'll bring it back to council table.
I'll make a motion to approve ordinance 15, series of 2024, the non-discrimination ordinance.
I'll second.
We have a motion and a second. Further discussion? Yes?
Yeah, thank you. I had concerns with why do we need to have an ordinance when basically the same coverages are extended through the state. And I appreciate the value of having a local ordinance and having more perhaps flexibility or control over complaints at the local level. So in the inclusivity in the survey was rather low, 59%. So I appreciate this, and I think that it does send a signal that we are concerned and that we want to increase inclusivity. So thank you for all the work on this, and I support it.
Thank you. Could we have a roll call vote, please, for ordinance number 15?
Counselor Doyle,
Yes.
Counselor Guth,
Yes.
Counselor Howenstein,
Yes.
Counselor Rose,
Yes.
Mayor Tory.
Yes. Thank you.
Thank you.
Yes.
Mr. Mayor, if I could, I would like to just put a clarification on an item from consent agenda.
Yes.
So I did make a misstatement about not having a GMP with gold. I just wanted to clarify. I had a momentary relapse because we did a construction manager as general contractor contract first. And then we did an addendum to do a GMP rather than going back out to bid. And so that is very unusual for us to use that process. It was also an extremely competitive time to find bidders, and gold was our sole bidder at that time. So again, my apologies for that misinformation at the beginning, and just wanted to share with you again that timeline. I'm not even sure it's this council that approved the CMGC contract. I believe it might have even been the council before the one sitting here today.
Thank you. Jim?
Mr. Mayor, staff is requesting council go into executive session pursuant to CRS Section 246402-4A, purchase, acquisition, lease, transfer, sale of real property, personal or other property interests. 4B, conferences with an attorney for purpose of receiving legal advice. 4E, determining positions relative to the matter that may be subject to negotiations. Specific item of discussion tonight involves the Theodore Aspen lease terms and negotiations related to Theodore Aspen's request for authorization to build a permanent structure in conference with the attorney, provide legal advice associated with the use of city property for the Aspen purposes. If the council chooses to go into executive session, the executive session will be recorded, and the recording will be maintained by the clerk for a period of not less than 90 days.
If anybody likes the sound of all that, we could have a motion.
I move that we go into executive session.
Seconded.
Thank you. We have a motion and a second. Can we have a roll call vote for going into executive session?
Counselor Doyle,
Yes.
Counselor Guth,
Yes.
Counselor Howenstein,
Yes.
Counselor Rose.
Yes.
Mayor Tory.
Yes. As always, we will let you know that we will be concluding our executive session and then adjourning the regular meeting. Immediately following, there will be no other business conducted. And we want to say thank you to Grassroots TV, as always. Thank you. Have a great evening.